And given that offshore visas are taking, 18 months-ish to process at the moment, um, that 6 months is going to be a big difference. And also from our experience, prospective marriage visas seem to be processing much faster.
And then we have honestly had instances where in visitor visa refusals, they've mentioned that if you made your partner visa application before, this visitor visa could have been granted, as opposed to visitor visas just being refused on you not being able to show that you're a temporary entrant.
Fantastic. So, in what instances would somebody consider a prospective marriage visa over offshore partner visa, Tamasha? Welcome to episode 3 of Visa Game Plan. In this episode, we're going to discuss strategies for making offshore partner visa applications. So, partner visa applications can be made onshore or offshore, and I think offshore partner visa applications require a lot of strategizing because it's much more complicated. So, there are two types of partner visas for offshore, right? The offshore partner visa and the prospective marriage visa. Do you want to tell our audience the difference between the two?
Right, so prospective marriage visas, as the name suggests, is for couples who are engaged to be married. And you make the application on the basis that you are intending to come to Australia and get married to your partner. On the other hand, the offshore partner visa is when you are in a marital or a de facto relationship and you are just making your application from outside Australia to join your partner.
Fantastic. So, in what instances would somebody consider a prospective marriage visa over offshore partner visa, Tamasha?
Right. So I think it's like I said earlier, if you're not married yet and you're planning to get married, your best option would be to make a prospective marriage visa. And there are other concerns like processing times where it would mean that you save a little more
I
time.
think that's actually the main strategy, right? Like, because for most clients, if you have a fiance, then they would say, okay, look, I'm going to get married in the next 3 or 4 or even 6 months. Why don't I just wait and then lodge it? But then that's 6 months of processing time you've lost. And given that offshore visas are taking, 18 months-ish to process at the moment, that 6 months is going to be a big difference. And also from our experience, prospective marriage visas seem to be processing much faster than the offshore 309,
Yes,
right?
we recently had several clients who got prospective marriage
In
visas
about 9 months or
granted
so
really
or less.
quickly.
Yeah.
Yes, yes.
I know that's probably because the prospective marriage visa requires the client to come back onshore and then lodge a partner
Partner
visa, the
visa.
subclass 820 once they come onshore, right? So how long is the prospective marriage visa granted for? What's the period?
Right. So generally, the department says that it's granted for 9
9
to
months.
15 months.
Yep.
And then, like you said, after they arrive in Australia, they have to get married to their partner and proceed to a 820 application.
Yes, so that's the real kind of the decision that you have to make when it comes to prospective partner visas. Do you do the prospective partner visa today so that you can get ahead of the processing curve, or do you wait and get married? Now, let's say a client comes and says, "No, look, we don't want to get married in Australia. We don't want to have to go through the hassle of making another partner visa onshore. So let's just do the offshore partner visa." Um, let's talk a bit about how the visitor visas really play into offshore partner visas.
Right. So, if you do apply for a offshore partner visa, like you said, the processing time is really long. You have the option of applying for visitor visas and then eventually coming to Australia and staying in Australia until the
On a
offshore
bridging
partner
visa.
visa processes. Yes.
Yeah, so I think from a strategic perspective, what we must really understand that visitor visas have some of the highest refusal
Refusal
rates,
rates.
right? So where a client is getting married to somebody offshore who doesn't have an extensive travel history, like they haven't gone out of their home country, or even if they have gone out of their home country, they've just been in their local continent, like an Asian continent or Latin America. You have to be very careful because the department may refuse the visitor
The
visa.
visitor visa.
But what I tell people is don't worry about it. Still do a visitor visa because the visitor visa refusal doesn't really have an impact on the subsequent partner visa
Partner
you do,
visa
right?
processing. And then we have honestly had instances where in visitor visa refusals, they've mentioned that if you made your partner visa application before, this visitor visa could have been granted, as opposed to visitor visas just being refused on you not being able to show that you're a temporary entrant.
Yes, correct. So visitor visas have this unique quirk showing that you need to be a genuine temporary entrant, which means you have to prove that you'll go back to your home country. But partner visas doesn't have that requirement. So as long as the relationship is genuine, you can prove the four-factor test, that is the nature, history, development of the relationship, the financial codependence of the relationship, the social acceptance of the relationship, and your future intentions with each other. The department has to grant the partner visa. But the visitor visa, very discretionary, they can refuse it. So for the audience, the strategy should be, if you're not married yet, let's do a prospective
Prospective
marriage
marriage visa.
visa, get ahead of the processing times. If you don't want to do that and you want to do an offshore partner visa, always do a visitor visa first. But if you're planning to use a lawyer, probably hire them to do the visitor visa as well, because we can provide much better evidence to the department and try to maximize the chances of that visitor visa being granted. So I think that's a good discussion on offshore partner visa strategies. Let's pivot a little bit and talk about onshore clients who are on bridging visas that want to make partner visas. If I am on a bridging visa inside Australia because either I've applied for a student visa extension or 485 or some other visa that has not been granted yet, or I've had a visa that was refused and I've appealed it to the tribunal, can I make a partner visa onshore, Tamasha?
So that client is essentially barred from making a partner visa application because the Schedule 3 of the Migration
So
Act
the short answer
comes
is
into the
no, right?
no.
Yeah, the short answer I think is no.
No.
You can't make that partner visa onshore unless you can prove compelling and
And
compassionate
compassionate
second.
circumstances, but proving compelling and compassionate circumstances is quite difficult.
Yeah, I think it's a very narrow set of circumstances. Usually, the most straightforward would be if you have a Australian citizen child
Child.
of the relationship. That's usually the most straightforward. Or otherwise, you have to prove that you were not able to depart Australia at the time of application. So, Schedule 3, guys, is operation of the migration regulation, which limits your ability to make an application onshore. So you can still make that application
Application.
onshore, but it's just that when they are going to grant the partner visa, the department's going to ask you to prove that you had compelling and compassionate reasons to apply onshore. So most of our clients, we rightly advise them to lodge offshore. So if a client comes to you, Tamasha, and says, "Look, I'm on a bridging visa. I want to apply for a partner visa," how would you go about it?
Right. So as we just discussed, the advice would be that they have to lodge their application offshore. But it involves a careful strategy where we first get the client a bridging visa B. Let's say they are on a bridging visa A at this moment. We get them a bridging visa B and ask them to leave the country. And while they are offshore is when we prepare and lodge the partner visa application. And then, so that will be a subclass 309 and offshore partner visa application. And then they will still have the travel rights to enter the country as
So they
second.
can come back to
They
Australia
can
again,
come
right?
back to
Yep.
Australia. And then from there on, after they are in Australia, we get another bridging visa associated with the partner visa that was lodged offshore.
And that second bridging visa has to be a manual application, right? It can't be
Correct.
through the IMI account.
Yes.
Yeah, and that's quite a complicated
Get the
process. And then
process.
after that, we can withdraw. If they are at the tribunal, we can withdraw the ART application.
Yes, yes. So that's how usually clients would work around if they are at the RT as well. After they've lodged the partner visa and they are in a genuine relationship, they can withdraw the ART application and they'll proceed to wait until the partner visa is processed.
Fantastic. There you have it, guys. So we broke down the strategies of making an offshore partner visa application in this case. And then we also broke down the strategies of somebody who's onshore, whose visa has been refused, how you should go about it. So if you found this episode helpful, keep following our podcast and we'll have more episodes for you in the future. Thank you very much.